Hi, I'm Kerry Brooks. Welcome to this video presentation on the iLOR case, which involves the terms in contrast, instead, also statements in a parent patent, and summations. iLOR, the patent assignee, filed an action against a competitor alleging infringement of a patent directed towards a method of adding user-selectable function to a hyperlink. The district court denied the assignee's motion for preliminary injunction on a particular claim and granted summary judgment of non-infringement on that claim. The patent asserted in the case is directed to a method for adding user-selectable function to a hyperlink. As stated in the abstract, the method described in the claims permits the user to interact with a hyperlink in a variety of ways without necessarily having to open and/or follow the hyperlink. The claims at issue are consistent with the method described in the abstract. The only disputed limitation of the claim at issue was the limitations, the toolbar being displayable based upon a location of a cursor in relationship to a hyperlink, which the district court construed to require that the toolbar is automatically displayed upon the placement of the cursor in proximity of the hyperlink with no further action on the part of the user. Because it was undisputed that Google's notebook does not automatically display its toolbar, but instead requires the user to right-click on the hyperlink to display the toolbar, the district court granted Google's motion for summary judgment of non-infringement and denied iLOR's motion for preliminary injunction. The Federal Circuit affirmed the district court's decision of non-infringement, noting that the prosecution history of the 839 patent confirms that iLOR contemplated display of the toolbar without further user action. During the prosecution of the 839 patent's parent application, iLOR distinguished a prior art reference to Newfield on the basis that it required further user action for display, not merely locating the cursor proximate to the hyperlink. Newfield does not teach detecting a cursor in proximity to the hyperlink. Instead, Newfield teaches that the user must click on or select a hyperlink to access the breadth-first search system of Newfield. In contrast, the present invention detects a cursor in proximity to the hyperlink. Therefore, Newfield does not teach detecting a cursor in proximity to a hyperlink. But iLOR asserted that these arguments are inapplicable to Claim 26, because it describes different aspects of the invention than the claims at issue during prosecution of the parent application. The Federal Circuit disagreed that these representations are inapplicable to Claim 26. The arguments made above were made to distinguish claims that contained inter alia limitations related to detecting a cursor in proximity of said hyperlink and displaying a graphical toolbar in proximity to said cursor while the cursor is in proximity to said hyperlink. Notably, these limitations are present in independent claims 1 and 9 of the 839 patent, and iLOR appeared to conclude that the arguments made during prosecution of the parent application are applicable to these claims. The Federal Circuit stated that when iLOR added 26 during prosecution, it argued that these claims are similar to and allowable for at least for the same reasons as the pending claims, including claims 1 and 9. iLOR's representation that these newly added claims were similar to the pending claims and its contemporaneous failure to put the examiner on notice that it was attempting to recapture previously surrendered subject matter renders the representations it made with respect to Newfield's reference applicable to Claim 26. These representations confirm that the claims, including 26, contemplated display of the toolbar without further user action. Applicant summation linked Claim 26 to the disavowal created in the parent application and patent. Going back to the statement by the patent attorney, it states that Neufeld does not teach detecting a cursor in proximity to the hyperlink. Instead, now the term instead is a notice to the reader that one idea was just stated and now a different idea, which is different, will be stated. Instead, Neufeld teaches that a user must click on and select a hyperlink to access the breadth-filled first search system of Neufeld. So it's saying that Neufeld is different than detecting a cursor in proximity to a hyperlink. More importantly, after the statement regarding what Neufeld teaches, the patent attorney used the conjunctive adverb. In contrast, the present invention, which is a generic expression of what's in the claims, detects a cursor in proximity to the hyperlink. Therefore, Neufeld does not teach detecting a cursor in proximity to the hyperlink. I hope you enjoyed this video presentation, and I hope you can see that different terms and expressions can identify differences between the prior art and the claimed invention that can give rise to a disavowal of claim scope. I hope you continue to watch the other videos related to this subject matter. Thanks for watching.